All right, Mr. Skinner, again, my name is Kelly James. I appreciate you taking the time to speak with us.
Books that my wife sends me to read, the book of yours that I just finished reading, yeah. I could look to my left and I could see the doorway, I could see the gurney, I could see the arm boards.
Oh, okay. Oh, well, they'll, okay.
It's a victory for your reporting efforts. It's a collective victory for justice.
But the Supreme Court issued the stay at 513.
Prosecutors say allowing convicted criminals to file civil rights lawsuits to undo their conviction.
I had had my last visits. They took me over there to the walls. I was in the death house.
Most people would say, why in the world wouldn't you do the test? How come we're having this big fight? Why has Mr. Skinner been in court?
It's a very long story. The marriage is really part of our personal life.
We outside on the other side of this glass, we do not know when we are going to die.
Henry Watkins. Henry Watkins Skinner was an American Row inmate in Texas. In 1995, he was convicted of bludgeoning to demise his live-in girlfriend, Twila Busby, and knifing to her demise her two adult sons, Randy Busby and Elwin Kaler. On March 24, 2010, 20 minutes before his scheduled ending, the U.S. Supreme Court issued a stay of ending to consider the question of whether Skinner could request testing of DNA. His attorney chose not to have tested at his original trial in 1994. A third ending date for November 9, 2011 was also ultimately stayed by the Texas Court of Criminal Appeals on November 7, 2011. On March 6, 2011, the Supreme Court issued an opinion holding that Skinner may sue under 42 U.S.C. 1983, claiming that Texas rules for seeking post-conviction DNA testing upon which the judges rely are too narrow or restrictive. The ruling did not specifically grant Skinner the DNA testing he had been seeking, but on June 1, 2012, the Texas Attorney General's office finally agreed to the analysis of the evidence required by the defense. On November 14, 2012, the Texas Attorney General's office released an advisory to the Gray County State District Court that convicted Skinner, advising the court that the DNA testing further implicated Skinner in the Busby family slayings. Among the findings, Skinner's blood was found in numerous places in the back bedroom, where Busby's two sons were slayed. Skinner's DNA was also found on the handle of a bloody knife. But along with DNA from one of the sons and an unknown contributor, Skinner's attorney, Rob Owen, has requested additional DNA testing to identify DNA from an unknown contributor on the knife and in the back bedroom. Additionally, the state lost a bloody jacket found under Twila Busby's arm, which Skinner claims belonged to her uncle, Robert Donnell, a convicted felon and accused molester of Twila. Skinner claimed that Donnell is the real slayer. On August 29, 2013, a private Virginia laboratory published the results of tests conducted on 4 hairs found in the hand of the slain woman, Twila Busby, and 3 of them show a family link with the 3 victims, but do not belong to them, with only one of them belonging to Skinner. These results could incriminate Robert Donnell, a deceased maternal uncle, who Twila Busby had told friends had molested her on multiple occasions and who had threatened her shortly before the slayings.
All right, Mr. Skinner, again, my name is Kelly James. I appreciate you taking the time to speak with us.
I would like to make 2 things clear at the beginning. One, I'm not an advocate of capital punishment.
Kayla, I'm wondering if you could sort of tell people where you left off.
Oh, okay. Oh, well, they'll, okay.
Last minute stay of execution, which, from reading at the time, you were prepared. You thought
to prove your innocence. What we are doing here is not an instrument for proving your innocence.
More to be investigated in Hank's case.
One really good interview that I participated in.
Here we go. All right. All right, thank you, Jerry. Okay.
As of September 2013, these findings had not been assessed by judicial authorities. On February 3 and 4, 2014, an evidentiary hearing took place in Pampa, Texas. Prosecutors argued that the tests only confirmed Skinner's guilt, while lawyers for the 51-year-old defendant said the results raised enough questions about the identity of the perpetrator that a jury would not have condemned him to demise. In July 2014, Judge Stephen Emmert issued a ruling saying that it was reasonably probable Skinner would have still been convicted of a triple slaying even if recently conducted DNA evidence had been available at his 1995 trial. The attorneys for Skinner said that they would appeal the decision to the Texas Court of Criminal Appeals. The Judicial District Court continues to rule that the DNA testing is not favorable to the accused, while the defense team considers that the presence of an unknown third-party DNA detected and the loss of evidence by the state should definitively rule out the reasonable character of the conviction and even more the demise penalty. Skinner was scheduled to be executed on September 13, 2023, his sixth scheduled ending date. However, he died in February of that year. Circumstances surrounding the slaying. The slayings occurred on December 31, 1993, at 804 East Campbell Avenue in Pampa, Texas. Skinner was convicted of the slayings on March 18, 1995, and sentenced to demise. Skinner lived with the victims and admitted that he was in the home when the slayings took place, but claims he was in a comatose condition from a near-lethal dose of codeine and alcohol. In a letter published in April 2010, Skinner put forth a new claim that he was colorblind and accidentally ingested the near-lethal mix because he had confused the victim's fuchsia pink glass, which contained codeine, with his own baby blue glass. Twilla Busby was slain in the living room, just feet from the couch where Skinner claims he was lying passed out on the sofa. After the slayings, Skinner claims he was roused off the couch by one of the mortally wounded victims, Elwin Scooter Kaler. Kaler died on the porch of a neighbor of Twilla Busby. Skinner made his way to the home of Andrea Joyce Reed, 4 blocks away, and she let him in. Reed initially testified that Skinner threatened her if she called the police. Later, however, Reed recanted that claim and said Skinner merely told her not to call the police, never actually threatening her. Skinner was arrested several hours later, being found in the darkened front bedroom of Reed's home. When he was arrested, Skinner was wearing clothes bearing blood spatters that were DNA matched to the 2 victims. Campaign for DNA testing. Despite pending litigation, Skinner was given an ending date of November 9, 2011. Gray County District Attorney Lynn Switzer, the respondent in Skinner's lawsuit, had written in a brief to the court filed on June 2, 2011, that Texas satisfied all the requirements of constitutional due process when it offered Skinner the opportunity to test the DNA evidence at trial. In March, the U.S. Supreme Court held that a civil suit against Switzer over post-conviction DNA testing could proceed, but it did not rule on whether Skinner should be given access to the actual evidence. A new Texan law, SB 122, took effect on September 1, 2011. SB 122 intends to ensure that procedural barriers do not prevent prisoners from testing biological evidence that was not previously tested or could be subjected to newer testing. On September 6, 2011, Skinner's attorney filed a motion in State District Court in Gray County, Texas, to compel DNA testing of key pieces of evidence that had never been tested. However, on November 2, 2011, Judge Stephen R. Emmert of the District Court of Gray County denied the third motion for DNA testing introduced by the defense, without explaining his decision. On November 7, 2011, the Texas Court of Criminal Appeals stayed Skinner's most recent ending so that a determination could be made about whether Texas law allowed for DNA evidence from the crime scene to be tested.
And at that time, that's when the thing was going on with Michael Richard and the CCA.
We outside on the other side of this glass, we do not know when we are going to die.
From that interview, a couple of things stood out. One, that Twyla and her uncle often got into arguments.
Been in that with my wife because I promised her if I ever get out of here. And it's 5:13. And so I thought, it just echoed in my mind, we close at 5. And I thought I had my last visits. They took me over there to the walls. I was in the death house.
It's a victory for your reporting efforts. It's a collective victory for justice.
I want out of here. I should have never been here to start with. And it's been a long journey. I could look to my left and I could see the doorway, I could see the gurney, I could see the arm boards.
On June 1, 2012, 1 month after an oral argument at the Texas Court of Criminal Appeals, the Texas Attorney's General Office stated that It no longer opposed a Roe inmate's request for DNA testing that his attorney said could prove his innocence. In November 2012, a further analysis of DNA evidence found Skinner's blood on numerous objects and furniture in the back bedroom where Busby's sons were slayed. It also found Skinner's DNA, along with that of Kaler and an unidentified third contributor on the handle of a knife found on the front porch. U.S. Supreme Court issues. March 2011 ruling. On July 22, 2010, Skinner's lawyer presented his brief to the U.S. Supreme Court. In it, he asks one question: may a convicted prisoner seeking access to biological evidence for DNA testing assert that claim in a civil rights action under 42 U.S.C. 1983, or is such a claim cognizable only in a petition for writ of habeas corpus? Skinner's lawyer's brief also notes, Mr. Skinner's suit for access to DNA evidence does not challenge the validity of his underlying conviction or sentence. Skinner's petition was heard by the Supreme Court on October 13, 2010, at 10 o'clock. The oral argument was widely covered by, among other media, The Washington Post. On March 7, 2011, the decision of the Supreme Court agreed that the civil rights action was appropriate in this case. Justice Ruth Bader Ginsburg wrote that a Section 1983 suit was available in cases where the relief sought by the inmate would not necessarily imply the invalidity of his convictions or sentence, since there was no telling whether the results of the tests Mr. Skinner sought would establish his guilt, clear him, or be inconclusive. She wrote, the suit was proper. Issues surrounding the case. Background. On March 24, 2010, 35 minutes before the scheduled ending, the U.S. Supreme Court granted Skinner a stay of ending to allow time to consider his petition for writ of certiorari. On May 24, 2010, the U.S. Supreme Court announced that it would review Skinner's case. The justices agreed to grant full review of the issue his lawyers raised, whether prisoners can use a federal civil rights law to request DNA testing after their convictions. At issue was whether post-conviction DNA testing is a civil right, even though the DNA, in this case, was available at trial, but Harold Comer, the appointed attorney of Skinner at trial, chose not to have it tested at the time because he believed it could be damaging to the case. Today, Comer says that even though he still defends his trial strategy, he would now request the testing. According to Professor David Protest, Comer failed to request DNA testing or present compelling evidence about the alternative suspect, and at the sentencing hearing, he failed to object to using Skinner's prior convictions, which he had prosecuted, to justify the demise penalty. Gray County District Attorney Lynn Switzer responded to the Supreme Court's decision to hear Skinner's case in a letter to an Amarillo news station. Switzer accused Skinner of gaming the system and said that, on 2 previous appeals, Skinner had failed to show how additional testing could exonerate him. Switzer's position was based on the decision of the Texas Court of Criminal Appeals, which had written, the appellant's request to compare fingerprint evidence would not provide a reasonable probability of the appellant's innocence, but instead would only demonstrate the presence of a third party. So the position of the Texas authorities was that the existence of a third party, being not an actual proof of innocence, was not a point to investigate. Claims against trial counsel. Comer was a former district attorney who had prosecuted Skinner in earlier cases before losing his position and pleading guilty to criminal charges over the mishandling of cash seized in drug cases. The Washington Post cited Comer's appointment as a possible case of cronyism. Comer was appointed to a highly paid case by a friend to help him raise the funds needed to pay off his overdue federal income taxes. Comer had twice personally prosecuted Skinner for other crimes, creating a potential conflict for him in defending Skinner. State law required the judge to hold a hearing on the question and give Skinner the option of a new lawyer if it became clear in the hearing that Comer had a conflict. But according to the trial records, Sims, who was aware of Comer's history with Skinner, did not hold such a hearing. Sims later approved $86,000 in legal fees for Comer's work in the case, one of the biggest sums ever paid to a court-appointed attorney in Texas. At the time, Comer was in debt to the Internal Revenue Service for about the same amount, according to court documents. Comer has stated, repeated on a 2018 episode of HLN's investigative series, Rose Stories, that right or wrong, he knowingly chose not to DNA test every single piece of evidence to at least give his client grounds for future delays of his ending by requesting tests at some future date. Witness recants testimony. The main accusation witness was Andrea Joyce Reed, who owned the house where Skinner was found by police several hours after the slayings. After the trial, Reed recanted several specific elements of her testimony. Reed's daughter's testimony, however, contradicted portions of the new claims, and ultimately, a magistrate found Reed's recantation not to be credible.
All right, Mr. Skinner, again, my name is Kelly James. I appreciate you taking the time to speak with us.
I could look to my left and I could see the doorway, I could see the gurney, I could see the arm boards. Denied all my appeals. The only action we had was in the United States Supreme Court, and if they didn't stay it, it was over with.
It's a victory for your reporting efforts. It's a collective victory for justice.
They anointed me with oil on my hands and my head, so I had went, I had extreme unction. There was no getting out of it, you know what I'm saying? And so I said, well, finish enjoying your meal. This is it, your bits for the salad, ranch dressing, tartar sauce, onions, and shredded.
Oh, okay. Oh, well, they'll. Okay.
But the Supreme Court issued the stay at 5/13.
We outside on the other side of this glass, we do not know when we are going to die.
Chocolate milkshake.
And your holding cell is only 5-6 steps away from the gurney.
Reed claimed that she had given false testimony at trial after having been threatened to be charged as an accomplice to capital slaying, to have children taken away, and to have her daughter called to testify at trial. Among the new claims, Reed said that Skinner told her not to call anybody but did not threaten to slay her. As Reed testified in court, Reed also claimed that she believed Skinner's statement, "I have kicked Twila, she's lifeless," to be a drunken fantasy like the other violent stories that he told me to explain how he was injured. Skinner has never commented on whether he asked Reed not to call anybody that night. According to Skinner, the phone cable was jerked out of the wall and nobody could call from the crime scene. Occupational therapist testimony. Occupational therapist Joe Tarpley testified at trial that, as a result of an injury sustained 6 months before the slaying, he believed Mr. Skinner's right hand's grasping strength was half normal at the time of the slayings. Tarpley testified that he didn't believe Skinner would have had the strength needed to choke Miss Busby with enough force to break her larynx and hyoid bone. Toxicology testimony. At trial, the defense's toxicology expert, Dr. Lowry, had stated that based on the alcohol and codeine in his blood, Skinner was too intoxicated to be able to physically commit the slayings, but his testimony was weakened by the original statements of Reed, which led the jury to accept the prosecution's theory that Skinner had developed a resistance to alcohol and codeine, which would have allowed him to function even under heavy doses. Lowry did not testify to when exactly Skinner ingested the codeine. The timing of the codeine ingestion has been called into question, but at trial, prosecution witness Howard Mitchell claimed that 90 minutes before the crime, Skinner was lying on the living room couch completely unresponsive. Harold Callant, Professor Emeritus of Toxicology and Pharmacology at the University of Toronto, reviewed several of Skinner's trial documents. Based on his review, Callant wrote, "I wouldn't be surprised if the heavy drinker would be able to move about somewhat, but he would be very confused and badly impaired, and would have difficulty standing or walking in a coordinated manner." Callant based his calculations on the assumption that Skinner consumed the alcohol and codeine at 9:30 the evening of the slayings. Theory about alternative suspect and physical attack. Shortly before the slayings, Twila Busby had been threatened by an uncle, slayed in an automobile accident when drunk driving on January 5, 1997, Robert Donnell. Though Skinner and his legal team have raised questions, Donnell was never considered as a suspect by the DA or the police. The skeptical juror reported on an interview with Howard Mitchell, the man who drove Twila Busby to the New Year's Eve party, by an investigator with the DA's office. According to Mitchell, Donnell had a history of violent behavior and attempted physical attack. Cliff Carpenter, an investigator for Skinner's appellate team, claimed to have spoken with Donald's widow, Willie Mae Gardner, and neighbor Deborah Ellis, who called Gardner grandmother, though they were not related. According to Carpenter, Gardner told him Donald came home very late the night of the slayings, and also that he thoroughly washed the interior of the truck, cleaned the truck's carpets, and repainted the truck within a week of the slayings. During cross-examination at an evidentiary hearing in 2005, Ellis testified that she did not see any blood in the truck and that Donald was just cleaning the truck. According to the Texas Department of Public Safety, Donald had no prior criminal history. According to the affidavit of Cliff Carpenter, Donald had a criminal history in Oklahoma for theft, embezzlement, and burglary in the 1950s, and served 3 years in prison in 1989 for auto theft. According to the state of Oklahoma, Robert E. Donald, white male, born May 5, 1930, 5'8", and 191 pounds, was incarcerated for 7 years, which may have included parole for one conviction of auto theft beginning on November 29, 1988.
It's a cacophonous all the time, but you learn to just tune it out.
Prosecutors say allowing convicted criminals to file civil rights lawsuits to undo their conviction.
Finish enjoying your meal, this is it. You're fixing to get on the bus to go to wherever, right? But you're on your way out of here. To do it. At first they said, no, that's not going to work. The Supreme Court has never allowed a prisoner to sue the district attorney. They're sovereignly immune.
Whatever you want to call it, the family won't ever be the same.
Why would you marry someone on death row?
I've always believed that. I believe in humanity. When I was out of here, before I came here, I was a people person. That time I was sitting there, well, I take that back. Yeah, it was 513 because, they were there. See, and I went back to this Osborne decision, which was the case preceding mine from time. So, 513, they issued the stay, and it took like 20 minutes for it to.
Other arrests are recorded in Oklahoma. No offense is attributed to Donald. There is also an affidavit by Ronald Campbell, an acquaintance of Twilla Busby, who said that on the night of the slayings he tried to place a collect call to Busby from the Gray County Jail, where he was an inmate, around 11 p.m. Campbell claimed that the oldest son answered but couldn't summon Twilla Busby to the phone. Campbell claimed the boy sounded upset and scared. Campbell also claimed that he could hear the noise of one hell of a fight in the background and the deep voice of an unknown male individual who wasn't Skinner. Phone records then corroborate Campbell's statements, so his testimony was not used at trial. On November 14, 2012, the Texas Attorney General indicated that the test's results on the physical testing kit indicated that Twilla Busby had not been physically attacked. Accidental codeine ingestion. It has never been clearly determined exactly how Skinner ingested the codeine, which he said made him comatose. Skinner's website has always claimed. It is believed that he was either accidentally or intentionally poisoned by the addition of the codeine pills to his drinks. In an April 2010 letter corresponding to what Skinner called false and undocumented allegations circulating on the web, Skinner put forth a new theory that he was colorblind at the time and drank from the wrong cup. Skinner himself explains, "A few years ago, I learned the truth from a toxicologist who testified in another guy's case here. He says that once you reach a certain level of intoxication, you go colorblind. Twilla has always putting pills in her drink and sipping that one drink all evening. I later learned her girlfriend had given her 13 furanol number 4 codeine that she'd put in her drink. Twilla and I had identical glasses, but hers was fuchsia pink. Mine was baby medium blue. I vaguely remember seeing the dregs of pills in the bottom of my cup and getting sick, passing out. I couldn't figure out how it got into my cup, so I thought someone must have poisoned me. I think now I was just too messed up and colorblind to tell our cups apart anymore. I accidentally got Twilla's cup and drank from it, thinking it was my cup." Unanalyzed crime scene objects. Skinner and his appellate team have repeatedly tried to obtain a DNA analysis on 7 other items found at the crime scene, including fingernail clippings, a knife found on the porch of Busby's house, and the second knife found in a plastic bag in the house, a towel with the second knife, a jacket next to Busby's body, and any hairs found in her hands that were not destroyed in previous testing. and private organ swabs taken from Twila Busby at the time of her autopsy.
If I ever get out of here, I'll be her love slave endlessly.
It's an individual who has had 6, 7, 8 bites at the apple.
All right, Mr. Skinner, again, my name's Kelly James. I appreciate you taking the time to speak with us. And the first thing we want to...
Books that my wife sends me to read, the book of yours that I just finished reading, yeah.
It was called The Lamp of Hope, and I started translating that newsletter.
I want out of here. I should have never been here to start with. And it's been a long journey.
It's the last time we spoke with you, you got that last minute stay of execution, which, from reading at the time...
At the time of the trial, DNA analysis had been performed only on the clothes that Skinner was wearing at the time of his arrest, and the results were incriminating because DNA of the two victims was found on the clothes. On November 14, 2012, the Texas Attorney General released a statement indicating that Skinner's DNA and that of an unknown contributor was found on the bloody knife on the front porch. Skinner's blood was also found in numerous places in the bedroom where Busby's two sons were slayed. Somewhere Skinner's blood had not previously been found. The jacket, found next to Busby's body, was lost by the state and was not available for testing. Hair clutched in victim's hand. During the post-conviction appeals, DNA analysis of only the hairs clutched in Twila's hand were tested, and the results may have been either exculpatory, with one of the head hairs and an unmatched fingerprint found on a plastic bag containing a bloodied knife excluding Skinner, or inconclusive, and no further analysis was made. All the requests for DNA testing of the other items have been denied on the grounds that Skinner's trial attorney did not seek DNA analysis. Lynn Switzer, the Gray County District Attorney, claims that additional testing would not prove Hank Skinner's innocence. The claim that Twila Busby had been physically attacked was not raised at Skinner's trial. Further, medical examiner Elizabeth Peacock testified at trial that Twila Busby was not physically attacked. An analysis of the physical testing kit, conducted in November 2012, showed Twila Busby had not been physically attacked. The hair in Busby's hands was from Busby, and a knife found on the front porch contained Skinner's DNA on the handle along with the DNA from an unknown contributor. Skinner versus Switzer. Skinner's defense team took a significant step by filing a complaint in federal court against Gray County District Attorney Lynn Switzer. Their grievance centered around Switzer's refusal to release crucial evidence to the defense for private DNA testing. This evidence could potentially hold the key to Skinner's innocence or guilt, and the fact that it might be withheld was deeply troubling. The crux of the issue was whether Switzer had the discretion to release this evidence without the need for a court order. It's a question that goes to the heart of fairness and due process within the criminal justice system. After all, if evidence exists that could exonerate a person, should it not be made available for testing without unnecessarily legal hurdles? In January of the following year, the magistrate responsible for the complaint recommended its dismissal. This decision, however, only marked the beginning of a lengthy legal battle. On January 20th, a federal district judge affirmed the dismissal, but that wasn't the end of the road for Skinner and his defense team. They decided to appeal this decision to the Federal Court of Appeals, holding on to the hope that justice would eventually prevail. What makes this case even more compelling is the letter Hank Skinner wrote to Lynn Switzer in January 2010. In that letter, Skinner alleged that his former prosecutor, John Mann, had lied about the results of the hair analysis. It was a startling claim, one that cast further doubts on the fairness of his conviction. Skinner's plea to Switzer was simple. All what I'm asking you, madam, is to do the right thing and test the evidence. This plea encapsulates the heart of the matter. Hank Skinner wasn't demanding a get-out-of-jail-free card. He was asking for the opportunity to test the evidence against him to ensure that justice had been served.
My head started buzzing and I'm holding the phone. I dropped the phone and I just slipped.
And is now unhappy that He's never gotten relief and wants the court to create for him.
But we were discussing that, and I was over there eating my last meal, and at that time, that's when the thing was going on with Michael Richard.
A big change happened. There was this case at the Supreme Court of the United States.
My whole family's just...
I think there's 2 or 3 people you would get on with, and Hank was one of them. Then that was in 1996.
Oh, for real? That's what it felt like. If a state court closes at 5 o'clock, you know the highest court in the land does, and my lawyers had already come to see me.
It's a plea for transparency and accountability within the criminal justice system, principles that we hold dear in any just society. In March 2011, the Supreme Court made a significant decision that affirmed Skinner's right to bring suit under civil rights law, claiming that Texas law regarding post-conviction DNA testing was too restrictive. This ruling recognized the importance of allowing inmates the opportunity to use DNA evidence to prove their innocence, a step forward in the fight for justice. Ultimately, the pursuit of truth and justice should always outweigh any bureaucratic obstacles that stand in the way. Texas Criminal Justice Reform Law. On May 26, 2011, the Senate of Texas voted unanimously for the Senate Bill 122, a criminal justice reform bill, expanding access to post-conviction DNA testing. This bill would allow post-conviction testing whenever there is biological evidence that has not previously been tested, or when the evidence can be subjected to newer techniques that might be more revealing than the results of an older test. The passing of this law would prevent Texas courts from blocking access to DNA testing in cases where DNA was not tested through no fault of the defendant. Skinner has maintained that the decision to not test certain pieces of DNA evidence was not his. Skinner claims that Comer made the decision believing the results would further incriminate Skinner. Texas Senator Rodney Ellis, who authored the bill, said, "Under current law, innocence is often being left to chance. Strengthening Texas post-conviction DNA law is an essential measure to improve justice in Texas." The bill was signed into law on June 17, 2011, effective September 11, 2011. Post-conviction history. Skinner maintains he is innocent and has repeatedly appealed his conviction both at state and federal levels. Marriage. Skinner married Sandrina Georges while on Texas Row in 2008. Georges Skinner, a French national, has been an anti-demise penalty activist for more than 30 years. Well before she met Skinner, she has corresponded with numerous Row inmates and has participated in numerous protests against the demise penalty. Georges Skinner was banned from visiting or corresponding with Skinner because of violations of prison policies, a charge both claim was fabricated. The Texas Department of Criminal Justice refuses to release records, so the claim cannot be supported or contradicted. Georgie Skinner has received the official support of the French government in her persistent efforts to save her husband from ending and prove his innocence. France generally opposes the demise penalty in all cases. Defense team. For the post-conviction appeals, Rob Owen, co-director of the University of Texas at Austin School of Law's Capital Punishment Clinic, was appointed to represent Skinner. Owen has represented Skinner since 2004, after his previous court-appointed attorney Stephen Losh died. Skinner's new defense team obtained a new evidentiary hearing in November 2005, the full transcript of which is available, along with numerous other legal documents, on the website set up to defend his case. Accepted, then rejected. On May 14, 2008, a limited certificate of appealability was granted. Skinner's consecutive appeal, a federal habeas corpus petition centering on inadequate performance by his trial attorney on issues involving the investigation of an alternative suspect and a blood spatter analysis, was denied by the United States Court of Appeals for the Fifth Circuit on July 14, 2009. On August 10, 2009, Skinner's defense team introduced a new petition for a rehearing en banc with the Fifth Circuit Court of Appeals. The petition was rejected on August 28, 2009. Ending orders. On October 26, 2009, Judge Stephen Emmert signed the order setting an ending date for Hank Skinner on February 24, 2010, which was the first ending date. The date was then changed to March 24th due to procedural errors that rendered the original mandate invalid. After the SCOTUS decision, Skinner was given a new ending date of November 11, 2011. That date was stayed to allow the courts to consider Skinner's request for DNA testing. Skinner resided on Row in the Allen B. Polunsky unit in Polk County, Texas. Skinner's writings. Skinner is the author of a series of self-published articles called Hellhole News, which covers a broad range of topics related to his case and the conditions on Texas Row. Prison issues. After a fellow Row inmate, Richard Tabler, used a smuggled cell phone to threaten a Texas state legislator from his jail cell, authorities conducted a series of raids aimed at confiscating the contraband phones. During the raids, according to a statement issued by TDCJ spokesperson Michelle Lyons, 2 SIM cards were found hidden in Skinner's Bible. Skinner denied having a cell phone, but an X-ray revealed an illegal cell phone hidden in his rectum. Demise. Skinner died at Hospital Galveston in Galveston, Texas on February 16, 2023. He was 60. His attorney said he died due to complications following surgery in December 2022 to remove a brain tumor. He is buried at Captain Joe Bird Cemetery. Articles and television coverage. On November 10, 2007, Al Jazeera International aired a 2-part program titled American Justice, Fatal Flaws, the second part of which deals with wrongful convictions and evokes Skinner's case and that of Curtis McCarty, who was exonerated from Oklahoma's Row after 22 years. As of February 2010, the Skinner case is included in the Mental Innocence Project of Professor David Protes. On February 24th, Amarillo News Channel 10 posted its full, unedited exclusive 30-minute interview with Skinner.
You have some people here who are mentally disturbed. They beat on the walls, they kick the doors.
Most people would say, why in the world wouldn't you do the test? How come we're having this big fight? Why has Mr. Skinner been in court?
It's a fact. And so I look up there at the clock, I'm eating my last meal, I'm talking to my daughter on the phone, and it's 5:30.
Tell us about it, because it's big.
Yes, it is. It is big. Well,
it's a very long story. The marriage is really part of our personal life.
other people think somebody's talking to them that's not, and they start screaming at them. And if they didn't stay it was over with. And so at 5:13, I said, that's it, it's a wrap, I'm dead, you know what I mean?
In March 2010, the Skeptical Juror site carried a 10-part series reprising the facts of the Skinner case. On March 24, the evening Skinner's ending was stayed. George Skinner and Curtis McCarty were interviewed on Larry King Live. Both pleaded against the denial of analysis of the full available evidence and expressed their belief that Skinner is innocent. On April 4, Twila Busby's daughter Lisa and Busby's uncle Dave Brito broke years of silence and gave an interview to News Channel 10 in Amarillo. Lisa was the only one in her family to survive the slayings and chose to stay at her aunt and uncle's place, keeping away from home because she was scared of her mom's boyfriend, Hank Skinner, might turn violent after drinking that night at a New Year's Eve party. Lisa Busby also appeared to advocate for Skinner's ending. "We are suffering, we have no closure, we have no peace because he's still alive," she said. Lisa finished her interview by agreeing that the testing needed to be done, saying, "I mean test the DNA and get it over with. That way we have something of peace and closure." On April 22, 2010, Skinner wrote Channel 10 a letter to clarify statements he made in an interview that was aired nationally. On May 3, Channel 10 produced a follow-up piece containing Skinner's letter to them regarding the statement he made. The statement in question related to the violent knifing and demise of the beating victims in the February interview. On camera, Skinner said, referring to the slayings, "If it had to happen and it had to go that way, I wish I would have done it, because I wouldn't have done them like that." On May 25, 2010, Time published an article about the case. In Demise penalty case, innocence has to matter. On June 10, 2010, Politics Daily published a report of recent interviews of former jurors at Skinner's trial, which states, Many of the jurors interviewed were taken aback by the amount of untested evidence, stunned that even the blood on 2 of the slaying weapons had not been analyzed. The 7 jurors agreed that all the evidence should undergo DNA analysis. On November 8, 2011, in the Huffington Post, David Protest described the succession of district attorneys who have prevented the DNA from being tested. On March 22, 2012, Episode 1 of the UK Channel 4 series, Roe, focused on an hour-long interview granted with Skinner. Taken from Forrest's site, Roe is a documentary series written and directed by legendary feature filmmaker Werner Herzog. That's all for this video, folks. See you next time.